Welcome to Notable Approvals. I am attorney Amanda Shaffer. If you missed us yesterday for Notable Approvals, that's because I was not here live. Busy day yesterday, busy is good, but I have a really exciting case to talk about today. It is a family law case, and it is one of those cases that I categorize as a marathon case, and that's because of how long it takes. This case has been going on now since 2016 with no real end in sight. A trial is technically set for June, but this is the third time it was set, and COVID made things even worse. But point is, we had a really big win on a motion that we had to file, and that's what I'm going to talk about today. I also am not going to go through all the history of this case. Obviously, 4 years is a long time, and that doesn't even scratch the surface of the amount of times these two parties have been in litigation together. It's been pretty nasty. It's been most of the child's life. So I'm going to do my best to give a brief overview of the situation and in order to understand this emergency motion or order to show cause that we filed. And I'll get to what an order to show cause is after I go through some of the history. So the two parties in this case were divorced back in 2010. They were at the time living in the state of Texas. My client was in the U.S. Air Force, and they had a child together. And when the child was a baby, mom decided she wasn't ready. She decided something. She picked up and went to Florida. The divorce proceedings started. It went on for a long time. And then eventually mom missed court and there was a default. So in Texas, what they do, if you can't come to an agreement, there's a standard like custody visitation agreement that gets entered, and it has these default provisions in it. So essentially what it did was it gave my client really primary physical custody with a whole visitation schedule for mom. And the visitation schedule talked about whether the parties lived within 100 miles or more than 100 miles. Those were the only two things that differentiated what would happen. Now, the problem is even when the parties were living more than 100 miles apart, which they were at the time it was entered, it allowed for weekend visitation, which you could probably, if you don't know anything about child visitation, if you think about having to go every other weekend more than 100 miles for visitation, it's problematic. On top of that, it gave my client the absolute right to decide where the primary residence of the child would be without mom's permission, without regard to geographic location, aka anywhere in the world. It said that visitation costs were to be split 50-50, and mom was given joint legal custody, which means that she was allowed to and had the right to share in the decision making. So this was entered, like I said, back in 2010. A couple years later, my client was transferred to the Air Force Base in Japan. And he had what was called a permanent duty station or a permanent change of station. I think it was a permanent duty station, yeah. And what that means is not a deployment where you're going into war. Obviously, we weren't at war in Japan. It is you're working for the military, of course, but you're allowed to bring dependents for this one. And so my client followed the divorce decree, which said you have to notify mom within 15 days of applying for a passport. But again, he didn't have to seek permission about the move in general. And at that point, mom really had been exercising her visitation rights very little. So my client moves to Japan, and mom kind of throws a fit. She tries to appeal things. We weren't involved at the time. It was still in Texas, and they did work out some type of Skype schedule, but mom never really took full advantage of it. Now we can cut to 2016. And in 2016, that's when my client called us from Japan. And he called us because his ex-wife, mom, had been calling his work repeatedly, claiming, and by work, I mean Air Force, claiming that he kidnapped the child. And every time the Air Force got this allegation, they had to look into it. So the only thing to really do is if we could get an order of protection to get her to stop harassing him at work. When this comes up, if she does try to call, she'll be violating the court order, but more importantly, able to show his superiors, look, this is the same thing. Even though every time he showed them the divorce, he explained it to them, but it still was making it really hard for him. So after kind of reviewing everything, he said to him, look, she lives in New York, you can legitimately file in New York. She's legitimately harassing you through a third party. But from what we can tell, just to warn you, you might be opening up the floodgates. And what we mean is there sounds like she's going to try to retaliatory file, file something, a cross petition against you, whether it's for custody or whether it's, some type of abuse or neglect, kidnapping claim. But based on what, the type of person she appears to be, we're just warning him. And he's like, you know what, I'm going to get fired soon, or, they're going to make me leave if this doesn't stop. So go ahead. So we filed it. And of course, she ends up filing a slew of litigation in response. One of those was called a writ of habeas corpus. If you've watched any of my other notable approvals live, I did one about a writ of mandamus. This is another type of writ. This one literally means to show the body. It's most often known in the context of a prisoner in detention trying to get out of prison. They file writs of habeas corpus. Essentially, she's saying to the court that he needs to bring the child before the court. And she claimed that my client was temporarily deployed in the military, which there is a provision in the laws that say if you're deployed in the military, that's like a change of circumstance, and it gets complicated, but essentially that was her argument because of the military. But again, he was in the military at the beginning. We filed a motion to dismiss that one. That one was gone. She also filed a motion to change custody. And she claimed that my client interfered with her parental rights. She said she hadn't seen her kid in 5 years, which was true, but again, so the visitation schedule, not only were travel expenses to be split 50-50, but my client, the pickup and drop off was supposed to be like literally mom for her visit goes to the residence, picks up the child, brings him back, and then when she's done, dad's supposed to pick up the child at mom's residence and bring him back. Again, this was this default provision that clearly wasn't gonna be able to be followed, but mom never even took any steps. She turns out couldn't get a passport because she was ineligible because she didn't pay child support, but then that was the other issue. Like I said, I'm trying to limit the topics here, the facts, but there's a lot. So essentially what happened was, so she files this change of modification. This thing is still pending. Since that time, we have been back and forth every few months in court. And we've had these temporary visitation stipulations so that mom can see the child. The child has visited her in New York, has visited her in Florida, where both sets of grandparents live. Since my client's no longer in the military side of the military, he's on the civilian side. He was honorably discharged, and now, and I'll get to where he is right now, and that's what this whole thing is about. But essentially, he didn't just come from Japan and come back to the US and that was it. And he ended up moving a bunch of times since we filed this lawsuit because of work. So he went from Japan to Korea. He was supposed to go to Germany, but then he was in Panama at one point where his family's from, Florida where the mom's family lives and his family. And then his last place before the most recent was New Mexico. So when they were in Florida, they were only about an hour apart, and mom, who doesn't work, came up from New York and would stay in Florida. And she does have 2 other kids as well. So that there were more visits taking place, but there were always problems. There's always something that would come up. So my client, when he left the military, he had a really hard time getting a job. And it was because he basically would have needed to go back to school to get a degree in order to get the equivalent job with the equivalent responsibilities, and he had to feed a family. He had his son, his wife, and then now he has twins. Took him about a year to get a job. He got a job with the Navy in New Mexico. And remember, back when I was explaining the facts of this case, that the divorce decree said my client did not need to get permission from mom to move the child's primary location, residence. So when mom got wind that dad was going to move to New Mexico in February of 2019, she filed a motion with the court to stop him. And we went to court, and essentially I said to the judge, look, he got this job. He wasn't required to notify her until he actually moves of where the child's going to be. She's trying to stop it. Here's all the proof of all the jobs that he's been applying for in Florida, and other more convenient locations, and he's just unfortunately not been able to get a job. So the judge did allow my client to make the move to New Mexico, but put in the order he is not to move again without court permission, which my client was like, that's fine. I'm not planning on going anywhere. I'm tired of moving. We want to settle down. So that brings us to the more recent filing, when about less than a year after my client started working there, at his new job, he started to experience discrimination at work. And it got so bad, his environment there was so hostile that he actually filed a discrimination claim with the EEOO office, and it was currently being investigated. I believe it still is. And he was told that due to the probationary period that he was in at work, they weren't thrilled he filed the complaint, but they might fire him, and that he wouldn't really have any recourse if they did. So he better start looking for a job. So a year ago, he started looking for another job. And again, it took a while. Finally, he tells me in this August, 2020, he finally got a job offer in Utah, Salt Lake City. And he was supposed to start soon. But, we had this court order. So I said to him, we got to get court permission unless, your ex-wife consents. And of course we tried, but we knew there was little or no chance of her consenting. So we filed what's called an emergency order to show cause, to allow my client to relocate to Utah with the subject child. An order of show cause is basically a motion, but it's an emergency form. So with a motion, you have to notice it, and there's a certain amount of days you have to file in advance. With an order to show cause, you can literally be in court that day. And that's exactly what happened. So we filed it. We saw this judge who wasn't our normal judge. And the judge was like, well, I'm not allowing the move yet. You need to go before your regular judge. So he gave us a new court date. And my client was able to push back a month his start so that he didn't have to worry about, what do I do? Do I move? Do I take a new job, lose my old job, keep my kid and my wife and other kids in New Mexico without me? Do I violate the court? Obviously we can't advise him to violate a court order, but he was in a pickle. So the mom, she filed opposition papers. The attorney for the child filed an affirmation in support of our order to show cause. The child at this point is 13 years old. He very strongly wants to remain with dad. He's never spent more than 2 weeks with mom. But of course, she filed not only an opposition, but a cross petition to change custody instead of allowing the relocation. So we go to court in September 21st, I think. And we said to the judge, if you don't grant him at least interim relief, he's going to lose his job. And he might not find another one for a while, and then he might lose this job, and he's the sole means of financial support for his family. This is a big problem. And the judge says on that court date, I don't care. You should have told us earlier. I said, Your Honor, when you're applying for a job and you get an offer, usually it's like you're going to start in 2 weeks. It's not like, start whenever you want or 3 months from now. And in fact, my client already pushed it back a month. So unfortunately, she, for some reason, didn't get one of the filings from the attorney for the children who had filed it online. And there was a huge part of the argument she was missing at that point. One other thing I didn't mention, this is the third judge on this case, which is not normal. 2 of the judges left for different positions. So it's like you kind of start over with the judge each time, especially when you have a history like this. It takes them a while to really understand what's happened. So now the judge knows everything, but when we filed this motion, she was still not as familiar with the case. So to our surprise, 3 days later, we got an email, and there was an interim order from the judge granting our temporary relocation, saying that I've read everything now. I do want to give the other side a chance to respond. However, it looks like this might be moot. There might be no point if I don't grant the interim relief because he'll lose the job. And there's a prima facie showing, so that we showed that there's a good chance we're going to win. That the two elements, which are the change of circumstance and that the relocation is in the best interest of the child. So she granted it, and then set dates for the opposition to be filed, and then oral argument date, October 15th. So October 15th, my client had already moved to Utah, which it didn't make sense for the judge to rule against us after that fact, but the judge certainly could have. We didn't know what mom's attorney was going to say. But essentially, we made our arguments that day. We had 10 minutes each. We explained to the judge that I explained that it was the change of circumstances was the issues at work with the discrimination, and then that he did get a new and better job. It was actually a promotion it was actually again with the Air Force. It was an old employer who he knew and was comfortable with, who he plans to build a life in Utah, in Salt Lake City. It was a main direct flights to Florida and New York where mom is. And we had to do the whole best interest argument. And we left that day, and the judge did not indicate when we'd have a decision. So it was a little stressful, but at the same time, if the judge is now going to deny the move, where does that leave my client? So we finally got the decision that granted our order in full, denied the cross motion to change custody. And what the judge said was basically, she agreed with what our argument was. Like I said, number one, the change of circumstances, that's easy. Nobody was really arguing that. Number two, the best interest analysis, and that's the most important thing. So there's a case called Matter of Tropia in New York that governs relocation cases for child custody relocation. And what it says is it's a case-by-case inquiry, but there are certain factors the court is going to look at when deciding if it's in the child's best interest to relocate with the custodial parent. So the factors that they look at are the reason for the parent is asking for the move and opposing, the quality of the relationship between the child and each parent, the impact of the move on the quantity and quality of the child's future contact with the non-custodial parent, the benefits, like economically, financially, physically, mentally, every way, to the child and to the custodial parent, and to allow the move, the feasibility of preserving the relationship between the parent and the non-custodial parent and the child, and then what the child wants, what the child wants is not dispositive. The older the child is, the more mature the child is deemed to be, the more weight his or her desires are taken by the judge. So in this case, my client, he's a very mature, well-educated 13-year-old, and he spoke about his reasons with clarity and logic. So it was taken very seriously by the judge. He did not personally speak. He spoke through his attorney, who made the argument for him. So by looking at all those factors, the judge determined that this was just a much better place for my client to live. He didn't lose the job, he didn't have to move jobs because of his fault. He was a victim of circumstance, of discrimination. There were the direct flights and cheaper flights made it easier for visits. They were already a flight away, so it's not like that's happening. The child and mom had plenty of contact. Mom declines to exercise a lot of even the visitation that we spend hours in court for those temporary visits that we arrange. She hasn't exercised all of them. She claims she can't even afford a lot of the flights because of her financial situation. Bottom line is, the judge granted our order to show cause. My client is happy and in Utah, but the battle is not over. Or so the battle is won, but the war is not over, I think they call it. So what was very strange about this case, also not strange, but unique, was that the timing of this motion, this order to show cause, doing this best interest analysis, is almost the exact same analysis that we're going to end up doing at the trial. Because when you look to change custody, so mom's asking for full custody. She's saying, you withheld the child from me, you interfered in my rights, I should get the child. And if she's telling the truth and that's true, then she could get the child in that circumstance, even though 12 of the 13 years he's lived with my client. And has never been with mom for more than like 2 weeks at a time. So, we wanted to be careful not to litigate everything now and then relitigate again because of the sheer time it takes to go through all of this. The oral arguments help because we need to call in witnesses and present evidence. But essentially, it kind of was like a mini trial for what we're going to have if mom doesn't agree to a new visitation schedule. And that's really what the question. I mean, especially after all this happening, the judge saying, look, to take the child, and he's 13 after he's lived with dad his whole life, and send him over to mom, that's destabilizing. And they said there's no proof of alienation because to show alienation, basically the child has to be like, I don't want to talk to mom, I don't want to visit mom. And in this case, the child says, I have no problem visiting mom, but just keep it to 2 weeks because I haven't been around for that much. And there are lots of other concerns we had with mom and where she lives and her situation in life and whatnot that I'm not going to talk about now, but all of it, everything was a factor in this decision by the judge. It was a 10-page decision for something, for a relocation, which is a big decision. So they still have time to appeal or object to it. There wasn't really much wiggle room, to be honest, but these things, I've seen more one-sided decisions get appealed before, but we feel very confident even if it got appealed, it would be quickly dismissed. And if the trial is in June, due to COVID, we're not sure. It's going to be virtual if it is, which will be interesting. A full trial virtually. The oral arguments were virtual. That was my first time doing that, which was interesting. But if we do get to that trial, because we can't reach an agreement on the visitation, then it'll be very similar issues. We really relitigate, kind of updating it and really delving into some of the stuff I didn't even bother getting into right now, with the history of the parents and what their lives are like and what the child's life would be like with both of them. The typical best interest analysis for child custody determination, whether it's an initial or a modification. The difference with the modification is you have to show a change in circumstances from the last time there was a custody agreement reached or custody order on the record. So that was a lot of stuff. This was one of my longest notable approvals so far, and that does not surprise me with a case like this. But this was I was so happy on Friday when I read this decision. I love when I read decisions where the judge I could have written it myself. That's how much the judge agreed with us. And now my client doesn't have to worry, and I hope everything works out with his job there and they don't have to move again, because then we'll be right back in court. But hopefully I'll have an update, next year sometime with this case to say, hey, this case is over. I think this case will go on until the child is 18. I hope not, for my client's sake. I love my client. He's been my client for a long time, and we've gone through so much. I've seen his child grow up. But, it's a lot. This is one of my most stressful cases. And I will be so happy for my client when he does not have to deal with this anymore. Well, that is all today for notable approvals. I will be back tomorrow for another one. I think I'm going to do an N600, which is a certificate of citizenship, if you are interested. And then, of course, we have Thanksgiving. So I hope if you don't catch us tomorrow, you enjoy your Thanksgiving. Thank you all for watching. Don't forget, the contact information has been scrolling across our screen this whole time. Make sure you like us and follow us on Facebook and YouTube and Twitter and Instagram and LinkedIn. I think that's all that we're on, so that you don't miss any more.